my main focus was getting him out on conditions of release or bail. So I haven't looked at everything yet. I think what's most important is that, as I suggested before Judge Ginsburg, the District Attorney's Office, they moved for dangerousness because they told a judge the day he was arraigned, the reason why we're asking for dangerousness, the reason why we want him held pre-trial detention is because he misled the police. And under the law, the District Attorney's Office absolutely has a right to do that. But to circumvent the statute by coming 3 days later and saying, oh, by the way, we don't really care about him misleading the police, that's not the reason why we're withdrawing our request for dangerousness. The reason why we're withdrawing our request for dangerousness is because apparently there was an autopsy done with this young man, and apparently from what the District Attorney said to the judge, he might have overdosed. So therefore, we're withdrawing our request for dangerousness. What concerns me is that the District Attorney's Office says one thing to a judge. This is why we're moving for dangerousness. This is why we want somebody held without bail. And then 3 days later, they say the polar opposite. We don't want him held on dangerousness. We just want him held on bail because apparently, unfortunately, this young boy overdosed. That's what concerns me.
You think they asked for a dangerousness hearing because they suspected that he may have played some role in the death?
That's absolutely why they probably asked for a dangerousness hearing, but that's circumventing the statute. The statute was not designed for a District Attorney's Office statewide to ask for dangerousness for one reason, when truly that's not the reason why they want someone held pretrial detention. This dangerous statute is so crucial because it allows the District Attorney's Office to go and ask for someone for 8 months to be held. If they're presented in district court, you can be held for 4 months with no right of bail. You could have $10 million in your pocket and not be able to bail. And then if the District Attorney's Office wants to indict someone, they move for dangerous again in Superior Court, which I believe they'll probably do on this case, and ask for a person to be held for another 4 months. So under the statute, a person can be held without bail for 8 months, no right to bail, pretrial detention. And for them to ask that this gentleman be held, my client, for 4 days, when 2 days into it, apparently what the District Attorney's Office told this judge, well, we had reason to believe that this young man may have OD'd. They didn't present that for another 2 days. My client was held without the right to bail for 2 additional days. Today when they have a chance, today when it's Friday, today when the hearing is on, when it's scheduled, then they present to the court with withdrawing our request. We just want a bail request. That's what concerns me.
Do you expect your client's family to be able to post the $7,500?
Yeah, we'll be getting out hopefully today.
How is your client handling the charges and being held?
He's never been to jail before. He's never experienced this before. I haven't talked to him specifically about what happened, what he did, what he might not have done. I haven't talked to him about that. He's a young man. You heard the District Attorney's Office talk about him having prior history before the court. He's got driving cases. He drove on a suspended license. He has a marijuana charge on his record. He's not public enemy number 1. So for him to be detained the way he was, he's really shaken up.
What was the result of that marijuana charge?
It was continued without a finding. He was placed on probation for a period of time. I don't know what the time was, it escapes me, and he completed probation successfully.
That was in